You'll be only indicating two.
Please rise for the constitutional court.
Judge Tina Suwengi, Advocate Samuel Gaidoli, Advocate Gina Sneman, Ms. Karabo Oza, Professor Teko Matigozi, Ms. Kalisa Mandi, Ms. Pinjel Kulu, Mr. Vitunelo Sakhala, the Executive Committee of the Student Education Society, partner organizations, and other esteemed guests, we welcome you to the first ever Public Interest Law Moot Court competition. After many rigorous rounds of written submissions and yesterday's nerve-wracking oral submissions before seasoned public interest law judges, after detailed training on drafting heads of arguments, and after training on making oral submissions before this wonderful court, the top two teams are now ready to appear before you justices and argue for human rights in South Africa. The Center for Applied Legal Studies, together with the Student Education Society, put together this moot court with the purpose of inspiring young people about the prospects of an amazing and fulfilling career in public interest law. Our hope was to spark not only the interests of young people, but also to expose them to some of the most brilliant minds within the sector. We wanted to mentor, to train, to teach, to guide, and then ultimately to see these beautiful participants fly. And might I say, they have done so. And so congratulations to the participants that are here today. You've earned your place to be here. We also today stand at the Constitutional Court of South Africa at Constitutional Hill, a place of significance for our country, a reminder of where we come from, and a hope for the future. Even as we navigate the difficulties that we face here today in our society, our present challenges in this nation, we hold on to the hope that one of the tools that we have, which is public interest lawyering, can help us shape the future that we want to see for this country. Whether it is landmark judgments that come, whether it is policies that are challenged and changed, whether it's power that's challenged, or whether there is landmark judgments that create change in society. All of these things are the possibilities that we can achieve, that you can achieve through public interest lawyering. And so, as we have today's final moot court hearing, may you be inspired, may you be motivated, and may you carry the baton to do even better for the future of this country. Welcome, everyone. So on that note, may we welcome our first esteemed guest. Advocate Samuel Gaidoli needs no introduction. He's a scholar of public interest law, he's a brilliant legal mind, he's an author, he's a mentor, he's a legal resource center in Nai, and might I say, an honorary council member. He has authored many books, law journals, chapters, many of which have informed public interest lawyering in South Africa. Please, esteemed guests, help me welcome Advocate Tamara Ndwele.
I presume that I can speak from here, given that today I'm not playing the role of counsel, but the role of judge. So thank you for inviting me, and thank you for setting this up. Before we started, I had a brief discussion with Karabo with Chambers, and I asked her, how does this thing work? Because I assumed that it was not for the first time. And I only learned now that this is actually the first public interest law Moot ever. So this is absolutely brilliant. And it's also brilliant for another reason, because I also complained to Gina that, people like Crystal Hayes and Arthur Charles, they started things, and we are just decolonizing everything, we're not starting anything. And I'm glad actually you have started something. So, which in fact is probably the most effective form of decolonization, is taking ownership and self-determination of the present and the future. I am supposed to talk about, I didn't realize that Settlement was also here, and I saw when he was introduced. He's an old friend of mine. Some intellectual disagreements, but it's all right. And that I admire a lot. So I'm supposed to talk about the future of public interest law, but I'm the guy who actually talks about its past. That's what I try to do, is to try and investigate its origins. And perhaps to talk about the future, we must always reflect on the past. What we call public interest law today has some resonances with cause lawyering, or lawyering in the interest of the marginalized and the oppressed and the occupied. In my own study, and which in fact I was quite pleased that those were the outcomes, I was a public interest lawyer. That's basically the first job I did in Grahamstown at the Legal Resources Center. And primarily involved with the very first cases that tried to interpret the socio-economic rights in the Constitution in sections 26 and section 27. And those were the primary concerns that the LRC at the time was engaged in. But it always struck me that I was the only black face in the firm, and the other lawyers around me were white men. And I always wanted to understand, how is it that white men are so concerned about black concerns, and that there are no black people who are engaged in the same topics of human rights that were of, at the time, much concerned, because the constitutional project was in its infancy stages. And that, obviously, I kept with me for a long time, and still I started investigating. When I began my research, I started to find probably black lawyers in the 1980s and black lawyers maybe in the 1970s engaged in a variety of human rights lawyering. What surprised me was to discover that they did not simply litigate human rights cases in the 1980s or the 1970s, but properly speaking, originated what today we call public interest lawyering. And it became clear that, in fact, I should not have been surprised, because the black lawyers who began to practice law at the beginning of the 20th century and who started at the end of the 19th century were almost driven to human rights cases, and today they are classified as public interest cases. They were almost driven to taking those causes because of the consequences of colonial conquest and the consequences of apartheid, and it should therefore not have been surprising. There are cases that they did particularly to resist the consequences of the Native Land Act of 1930. At the time, the entire judicial system was hostile, because it was a colonial system whose primary function was to serve as an extension of colonial government. government, and the courts were simply no more than an extension, an arm of the colonial administration. But notwithstanding the hostile setup, a setup that was designed to work against the interests of the colonized, what we find are early lawyers that began to think about how, in fact, to take the instruments of law that are designed to work against the interests of the marginalized and to turn them on their heads. One of the quotes that is usually cited from Cecil John Rhodes is when he claimed that there should be equality for all civilized men south of the Zambezi. And by civilization, he meant that people should acquire property, they should agree to conversion to Christianity, and they should obtain education. And that was a way of assimilating into a white society, and assimilating into a white society conferred you civilization. But Pitzkela Zalasen, who is the third, in another book he has been referred to as the second, but I'm glad to announce that actually they are all wrong, I'm right. He was in fact the third black lawyer practiced in South Africa. Questions this in 1923, and he says we have now acquired civilization, we have acquired private property, we have acquired education, we've even converted into Christianity, and yet we still have no equality. And that thing then runs through virtually all of his work, whether it was in land, whether it was in ejectment from property, or whether it was in fact in relation to political cases. But the thing runs through all of his work. The same as someone like Mangena, his work also is characterized and informed by trying to defend the interests of the marginalized. Much later, Nelson Mandela and Oliver Tambo were to set up their own fair. Some books, I am glad to see that two of them have now been corrected. Some books claimed that Nelson Mandela and Oliver Tambo set up the first Black Law Fair in the 50s. They didn't. It was probably the 6th or the 7th Black Law Fair that was set up in the 60s. And Oliver Tambo says that because black life was criminalized, and what he means was that once they took the land, they forced everyone who came back to the land, every African person who tried to come back to the land, they forced that person into a status of a criminal. And because black life in that sense was criminalized, they were almost driven to taking human rights cases and litigating those cases. We know what happened to Oliver Tambo. He was driven to exile. And at the same time as he was being driven to exile, his partner, Nelson Mandela, was being arrested, and he was also having to raise a young family, and his life personally disintegrated. Oliver Tambo's life didn't disintegrate because his wife left with him to Sweden first, and later on to England. But the promising fair, which probably would have been the fountain for today's public interest litigation, fell apart, Tambo and Mandela. A subsequent fair started by Semen also fell apart. Much later, only in the 70s, do we then obtain the modern version of public interest litigation, with the growth of organizations like the Legal Resources Center, organizations like the Lawyers for Human Rights, and organizations like the Center for Applied Legal Studies. They continue a long trajectory, which at the time is probably 70 years old, 80 years old, 90 years old, a century old. But they take the mantle that began from the likes of Semen, the likes of Magena, the likes of Msima, but they don't originate it in any way. So in many respects, today's public interest lawyers, and I'm very pleased to see that most of you are Africans and will be speaking today. And if you are white in complexion, you're still an African. In fact, can I tell you a joke? I want to speak about my book actually in the University of the Free State. Okay, it's a joke now, but it's not a joke for the person who spoke. I want to speak about my book at the University of the Free State in 2018. The main title of my book is called The Land is Ours. And a white female student stood up in the middle. The whole hall was full of black students who were very annoyed with apartheid and very annoyed with the fact that blacks do not have their land. And this white kid stands up and he's got a copy of my book, and then he says, I agree with this book, the land is ours. So, I mean, the argument was not lost on everyone, but she silenced the entire room. So when I say that the land is also yours, even for her, and she came with that as belonging to her, which was both later correct, but completely inappropriate in the context of that discussion. The point I'm trying to make here is that when you claim the space in public interest lawyer, you are reclaiming an old space that actually began with your ancestors. And they were driven into the space because they had to fight a colonial and apartheid system. Now, of course, we may say that colonialism is gone, but that is to delude ourselves. We may also say that apartheid is gone. That too is a delusion. The former apartheid is gone. Apartheid is law. Apartheid as justification is gone. But its legacy continues to operate. Today's South African inequality is largely racialized inequality. There is, of course, a quarter of Africans that have joined, properly assimilated to the upper echelons of society. But the majority of African people still live on the margins of society. The question is who, in fact, is going to take up the cudgels and fight for them through the Constitution? It seems to me obvious, as it was obvious to say, that perhaps it is today's African lawyers that will take those cudgels forward and reclaim the space that legitimately belongs to them. But today, the climate is not as hostile as it was in 1920 or in 1923. Today's climate is informed largely by the Constitution. There is, of course, a danger. Our Constitution today is blamed for all manner of ills of society. It is by no means imperfect. It is by no means structurally perfect. And yet, it still provides us with probably the most helpful guide to navigate a treacherous terrain that is largely characterized by inequality. So, although I am a constitutional convert in that sense, that it's impossible to think of my views as outside of the framing of the Constitution, we should not look at it in an uncritical way. We should always look at it in a critical fashion. Yet it remains the key instrument for us to drive social change. So what are we going to do then for the future? I think what we will have to do for the future together is firstly to change the face of public interest learning. You have all read the cases of the 70s, Common. You have read the cases of the 80s. You've read the cases of the 90s. What would have struck you are the living counsel in those cases. That must change, but it will not change by rhetoric. It must be changed by us collectively. You must play your role in changing the names of the advocates who appear at the end of each judgment, which means that you have to stay in public interest litigation. It is not always lucrative, but you only get the rewards if you stay the course. But you are also challenged by funding problems, which means that you have to think about how we sustain public interest litigation, particularly because the funding is drying up. This is not the 70s. South Africa is not a special case anymore. In the 70s, it was a special case because apartheid was perceived quite correctly as this abhorrent social system. And people who funded the fight against apartheid perceived themselves as playing also a morally correct role. We no longer have that. We no longer have the status of South Africa as a special case in the world. So which means that we have to fight alongside other people in order to legitimately claim our space as South Africans in order for us to obtain the necessary funding. But it also means that we have to be looking at local sources of funding. Public interest learning is not a very sexy place to find. So, which means we need to integrate with the bar, we need to integrate with the sidebar, and public interest lawyer is no longer the preserve, or in fact can no longer be the preserve of a few organizations. It needs expansion. Dumisa Nsebenza once made the point that at a certain point of his life, he was told that he is not doing public interest law, and he tried to compare the kind of work he was doing and what is claimed to be public interest law, and then he found that there was very little distinction, but it is just not classified as public interest law. And that means we have to start working with the sidebar, and we have to start working with the bar itself, so that public interest law is not something that is seen other, but it is mainstreamed into the ways in which we practice. That means we need to think creatively. But we also need hard skills, and I say this with a bit of trepidation, because many people perceive public interest lawyers as the soft lawyers, not really quite lawyers, because they think about justice, they don't think about law, and in order to be a lawyer, you need that cutting edge, that takes you over. Luckily for my own sense, I have been in a public interest organization. I've stayed for a long time, including 3 years as a director. But I've also been in a mainstream commercial firm. I am happy to announce that I think there is more rigor in public interest firms than there is in commercial firms. And why I say that is because we never took a case at the Legal Resources Center unless we had satisfied ourselves that the prospects were at least arguable. And when we took a case, we always made sure that the pleadings were perfect, the heads of argument were perfect, and to the extent that we could, the case that we brought was an unarguable case. When we knew that we were trying to build a class action, we started with test cases. And until we had established a line of jurisprudence, we would then bring the big case that would change everything. That kind of strategic thinking is not present in commercial firms, because they are primarily driven by commercial considerations, which you will not find in a public interest lawsuit. So although the perception is that there is less than public interest organizations, my own experience having occupied both spaces in my life, which is a short life, or maybe a long life compared to you, which is a long life. I believe that there is greater rigor in public interest organizations. So you should not fear the perception that you are losing out. You may in fact be gaining more by staying in public interest organizations. You are also challenged individually by lack of resources. Your parents are making demands on you. Your siblings are making demands on you. And there is not enough cash to distribute to the family, because public interest organizations simply cannot afford to pay the same salaries that you would have been able to get had you been in an organization. But of course, there are in all of these things, like in life, sometimes there are sacrifices, sometimes of a short-term nature, sometimes of a long-term nature. But we would be naive not to factor in those personal considerations. When I finished my stint at the Constitutional Court, I had lunch with Judge Sassin, of whom I was tracking. He asked me what I would be doing next, and I had a very lucrative job at Roman Gate, which I must confess I was going to take. He did say that at the time he came to the Legal Resources Center, his financial position was much better than it could possibly ever be for me, who came from, I don't like the term disadvantage, but anyway, it was disadvantage. Came from a black background, all of the backgrounds are the same. I had a mother to look after, siblings to look after, etc. But even now, I still have much more siblings to look after. Anyway, so the point I'm trying to make, I think you get a picture that you have to make those choices. And if you decide that for a temporary period you need to go to a commercial firm, don't feel bad about it. It is part and parcel of the choices that you have to make. So the final thing I want to say is to say I am excited that African children are in the lawsuits. I think I saw there that it was Rhodes and UJ that have come to the finals. And I remember being at Rhodes and being in an LLB class and finding that out of 90 students, only 2 were black, and the 2 that were black were from Zimbabwe, and there was not a single one that was South African. But I look at today and I see that the picture has changed. So I think the future is very bright and I'm very excited about it. Thank you very much.
Thank you so much, Advocate Tembe, for those words. So CARS and SLS are here today because we have committed, just as Advocate was saying, to the building of the required human capital, who are also rigid and have the ability to take the field forward. So I'm excited. It's been an exciting journey. We started about this time last year, and today marks the conclusion of the first ever public interest law boycott competition in South Africa. And before I proceed with what I'm going to do today, can I just give a hand of appreciation to Advocate for this speech that he gave. So yesterday we had 4 teams competing for the final, for a place in the finals. I'll just trust them to the 2 that did not make it through to the finals to say as give them a hand of appreciation as well. Thank you. You guys are awesome. I'm going to proceed to introduce the teams that we have today in finals. We have Roth University, whose team highest name is PO62 as counsel for the applicant. We have going on Chris Kogoda. And we have Christopher Tobayo. And to the leader from Oregon. Then we have the University of Johannesburg being represented as counsel for this one. It's represented by Samantha Smith, Ray George, and Tabitha Tuli. So the second task that we have here today is a bit overwhelming. I've been tasked with the duty of introducing the judges who will be presiding over this matter. And as a disclaimer, the people you see behind me here, they have bios that if I attempt to read them all throughout, it might be the focus of today's function. And we might not have time to proceed to court. So I picked the parts which I found interesting that you may want to know. So we have, I will refer to them as justices because that's what they advocate for the purposes of this particular event. We have Justice Tina Suweli. She is a second judge in the High Court, the Gauteng Law Division. She has also previously acquired a wealth of experience in legal practice as an attorney and an experience acquired from a period lasting for over 2 decades. She's also a board member of the African Leadership Initiative. She holds an LLB degree from the University of KwaZulu-Natal and a Bachelor in Social Sciences from the University of Cape Town. She has established herself as a social scientist, a critical thinker with a tangible experience in corporate governance and institutional accountability. In 2018, she published a thought-provoking piece entitled Legal Monopoly and Gender Transformation. The book has thematic concerns centered around the inclusion of females and women practitioners in the legal profession. It's like I say, I picked the interesting parts from the bio, so I would recommend that you look into that piece. It's very important. Also seeing that there appears to be more women in this this gathering that they amend. And also, there's in the participation composition, we appreciate the 2 ladies who made it to the finals, and we also have 3 ladies who are also there in the semi-finals, which is something that we are proud of because we want to have such representations even in the field of our public interest law. Please put your hand together as I ask Justice for the purposes of this gathering, Justice Tina to just. Alright, we also have Gina Silman in our midst, Justice Gina Silman for this particular gathering. She has been an advocate with the Johannesburg Society of Advocates for almost 10 years now, that's a decade. She has special expertise gathered from an experience spanning over a decade in the legal field, specifically in constitutional, administrative, environmental, and labor law. She also has experience and a wealth of knowledge when it comes to general civil and criminal litigation. There's an interesting connection that she also has with COWS, which together with SLS are the organizers of this public interest law competition. So she was an in-house at Center for Technical Studies, and she also worked with lawyers of human rights. And she actually holds an LLB degree from Nelson Mandela University and an LLM degree in human rights and democratization of Africa from the University of Pretoria. Justice Tina Silman. We also have Ms. Presiding Justice over the event today, Karambo Hoza. Mrs. Hoza is a director at Center of Child Law, which is also another public interest law organization. I've had the privilege of participating in one of the Moot competitions that they organized some years back. It was amazing. She holds an LLB and LLM, both of which she attained cum laude from the University of Pretoria, and she has also been involved in various research projects, both nationally, regionally, and I can say globally, which have shared policies around child law. Please help me celebrate Mrs. All right, so thank you again to everybody who is joining us. There are people who are streaming through the COWS YouTube page, and there are also people who are streaming from the Student Litigation Society's Facebook page. And we are also grateful for those who came here and to support the participants in person. Thank you so much. And at this point, the proceedings of the court will begin. Thank you.
I call the matter of Kolani Moyo versus the Minister of Justice and Correctional Services for hearing.
Good morning, court is in session now. The applicants may rise and introduce yourself.
Good morning, Justices. My name is Dr. Moot, and I am appearing on behalf of the applicant, along with my co-counsel, Christopher Gogoda.
Is your microphone on?
Hi, Justices. My name is Dr. Moot, and I am appearing on behalf of the applicant, along with my co-counsel, Christopher Gogoda, and Christopher Gogoda.
Can you just ask them to go slow with the last council's statement, because you need to write it down.
Just provide.
Tobias.
Yes.
Thank you.
The respondents can introduce themselves when they do the response. Just apologize, just to run through the rules, which you are familiar with both sides of 30 minutes. You have decided how to divide up your time. You will enjoy the 3 minutes protected time, each of you, after which then we will then ask you questions. So can I ask the applicants to address you there, please?
Justices, the application before this honorable court is a leave to appeal application. I will firstly take the court through the history of the case. This matter was first heard in the High Court, and the matter in the High Court was dismissed on 3 grounds. The first one was that the applicant was not able to prove that the arrest was unlawful. Secondly, the applicant was unable to prove that the correctional service officials actually caused the applicant to contract for COVID-19. And lastly, the court held that the prison put in adequate and reasonable measures in protecting the applicant from contracting COVID-19. The applicant applied for leave to appeal at the Supreme Court of Appeal, and this was denied on the basis that there was no visible prospect of success. It is against this background the application is brought for leave to appeal. I shall now deal with the merits of the appeal. It is submitted to this honorable court that the appeal should be granted on 2 grounds. Firstly, in terms of section 1667 of the Constitution, section 1673b(1), section 167, it states that the Constitutional Court may hear the issues of constitutional matter when dealing with cases where parties seek to protect or enforce their constitutional right. In this matter, the applicant's constitutional rights are violated and he seeks to enforce his constitutional rights. Secondly, the application of leave to appeal raises an arguable point of law, particularly government matters of general public importance. It should be considered if the application is heard and the matter served by this court. It will assist and provide justice to those in similar positions to the applicant, in similar positions to the applicant who have suffered the same treatment and conditions. Furthermore, the applicant submits that the application carries great prospect of success. In the High Court, it is submitted that the application, the decisions of the High Court, respectively, that the High Court respectively must have been supplied the law in relation to who bears the burden of proving the lawfulness of the arrest. And in relation to other things, the High Court failed to consider the binding precedent of this court. Against this background, the applicant submits that it will be in the interest of justice that this honorable grant the leave to appeal. If the court pleases, I will deal with the issue before this court.
Yes, you may proceed.
There are 3 issues before this honorable court. Firstly, this is the issue of whether there is a systematic failure by the officials of the Department of Correctional Services Department in taking adequate precautionary measures in protecting the applicant from contracting, their constitution, from violating their constitutional right. Secondly, the issue is whether the Correctional Service Department put in mechanisms that were reasonable and adequate in preventing the applicant from contracting COVID-19. And then the third issue that relates to the court is whether there was systematic failure. There was systematic failure by the Correctional Department to put in reasonable adequate mechanisms. Apologies. The second issue was whether the South African police service arrested the applicant. When they arrested the applicant, they violated their constitutional right, and subsequent to the detention of the correctional services was unlawful. I shall not deal with the first issue, and my co-counsel, Mr. Chris Kobado, will deal with the second issue, and Mr. Chris Kobado will deal with the third issue. Before dealing with the issue, I would like to address the court in the context of which this matter arises. After our 1994 The goal of the Constitution and aspirations particularly centered around breaking away from the injustice of the past, particularly related to prisons, the cruel and inhumane treatment and conditions in prisons. It is unfortunate that after 27 years of democracy, the legacy of apartheid can still be traced in our prisons. And the center of all of this, along with other cases that have come before this court, is the state's inability to fulfill their constitutional obligations. It is against this background that the applicant has suffered from conditions that are inhumane, degrading, and therefore infringed his right to dignity.
Sorry, Mr. Ramukoko, can I just take you back to the need to appeal? There is case authority by this court, which is cited by both parties, Link versus Minister of Correctional Services, which settles the law. Is this not simply a case of applying the law onto existing facts? And if that is so, why should we hear it?
Thank you, Justice, for your question. The network between me and Minister of Correctional Services is similar to this case. However, it is distinguishable and the fact that the applicant in this regard is not bringing the issues are not only centered around the infection of COVID-19, but rather the other two issues relate to the violation of the constitutional rights and the detention of the SAPS, as well as the arrest of the South African Police Service and also the detention of the correctional services.
Yes, but cases about violation of rights and cases about the legality of detentions, there is also plenty of case authorities. What I'm trying to say is, what is the unique attribute of the case that warrants this court to hear it? You've submitted, as I understand, that the interest of justice hinge on, as I understand, two questions. One, you said because of the violations of rights, and then you said because they are arguable because of law. So I just want you to articulate this arguable point of law that you say gives this court jurisdiction.
Thank you for your question, Justice. The distinguishable factor between the two cases is that this case arises under unprecedented times of COVID-19. And particularly it relates to the mechanisms that the Department of Correctional Services put in place in addressing the methods of preventing prisoners from getting infected by COVID-19.
No, I understand that. I'm sorry that this is the last time. I understand that it's COVID-19, it's not TB as the case is legal. But what's the legal distinction that you are trying to draw that would give this court jurisdiction?
Justice, may I please consult my co-counsel?
That's fine. You may also proceed with the other arguments and come back to the question later.
Thank you. As I will deal with the first issue before this court will be broken down into three parts. The first part is that we'll discuss the constitutional rights that the applicant is entitled to. Secondly, as a supplemental first, the obligations of the state in relation to the applicant. The second part will relate to the statutory reach by the officials in relation to the applicant's rights in terms of the Correctional Services Act. And then lastly, we'll deal with the constitutional violations that flow from the Act. In this matter, in terms of Section 35B, Section 35(2)(b) of the Constitution, the applicant is entitled to be detained in an environment that is consistent with human dignity. In addition to this, the state has an obligation in terms of Section 70 of the Constitution to provide, to respect and protect the rights in terms of the Bill of Rights. And in the case of, for instance, the President of South Africa, the court held that this duty of the state should take deliberate and reasonable measures to give effect to all fundamental rights in the Bill of Rights. And the purpose of the Correctional Services Act is that it gives effect to Section 35 of the Constitution, which is the right that entitled to the applicant. And in this case, we shall proceed to show how the officials breached the constitutional obligations in fulfilling, protecting, and respecting the rights of the applicant. Firstly, in regards to the second part, the obligations are breached on three grounds: under admission to the prison, in terms of health and accommodation. With regards to the admission to the prison, it is required that when the applicant is admitted or arrives at the hospital, they must be screened and tested for any communicable disease or contagious disease. And in this regard, the applicant was merely screened by asking questions, and they relied on self-questioning by the inmates on whether they are symptomatic to COVID-19. However, in the pursuit of the case, they have dealt with a similar issue with regards to the officials providing adequate and reasonable measures in protecting inmates from being contracted tuberculosis. And the court in this instance found that the screening process was superficial. And in terms of this case, it was because of the nature of TB as well as how it is transmitted. Similar to this case, with COVID-19 is also a communicable disease, a contagious disease that is transmitted similarly to TB. It is submitted that it is also, the method put by the officials is also superficial in this regard because it does not put adequate measures in preventing the contraction of COVID-19.
Council, can I maybe ask a question? So I've read your submissions, and on the point about screening and self-reporting, I just want to hear you on practically if the respondents are saying what they were doing is reasonable under the circumstances, which we know every place where we went, that's the simplest method of screening that is being used till today, even while we're still under the COVID regulations. What would you argue should have been done extra? When somebody is getting admitted, and also then during that time, we take a point that self-reporting is also problematic. But one would say these are adults, if they start experiencing symptoms, they would come and say, well, I'm not fine. And I know we get to the point where he does self-report your client, and actually, there is a delay in getting him to go to hospital. But I think I would just want to hear you quickly on the practicalities of it. What would you have expected? Because the remedy must also link with what is reasonable and unreasonable in the context of that particular circumstances.
Yes. In relation to this question, I would first like to point out that when the state or when the correctional services admit someone to their facilities, they do so in the person who is admitted does so involuntarily. And in the case of reviewing this Minister of Correctional Services, it states that when the ordinary citizens, the test of treatment should not be the same as those ordinary citizens, and that the state holds a higher standard. The higher standard should be applied to prisoners. And in this regard, the more practical solutions should have been the method that's required by the ordinary citizens, which are not even given to the prisoners.
Sorry, I don't understand which method is that. I mean, short of the screening and the temperature and all that, the next thing is to then say that every prisoner that was getting sent to the cells must get the test. What do they call it? The viral, the medical kind of testing that they do for the virus. Is that what you're saying? That should be done?
No, what I'm saying is it relates to, for instance, there is a requirement that everyone must wear a mask. And in this regard, there was not issued to the prisoners.
Okay, I understand. So there's a difference between the screening and then the protective equipment. So also your point is that there was not adequate protective or any protective equipment.
Yes.
But I was asking about the screening because you make a big point of the fact that the screening was inadequate.
Yeah.
After that, then you get to the fact that there was no PPE and then the space was small. But anyway, you can continue to argue.
If I may, I have a follow-up question to this. Mr. Walker, if this court were to find that there's been a systemic failure of the Department of Correctional Services, either in screening or in prevention during the course of detention, the appropriate remedy is important for this court to order. And the applicants have asked for constitutional damages. How will an order of constitutional damages in the applicant's favor assist in addressing the systemic issues if the court makes a finding that there are such systemic issues? Would not a remedy that incorporates a form of structural intellect to enforce that this does not continue be more appropriate?
Thank you for your question. In order that the department must, for instance, restructure their facilities and ensure that there are booking mechanisms that are adequate. It would relate to the doctrine separation of powers, and where the court will now be telling the executive on how to execute their duties. But in this regard, it is a matter of ensuring that the department is fulfilling their obligations and putting adequate and visible measures in this area.
I'm interested in ensuring that you complete your argument. I think that I have a follow-up question, and perhaps you might deal with it in reply, which is that if the state's defense is that whatever services that we provide within our available resources, I want to understand, given the idea that there is a separation of powers between what a court may order, what are the parameters of what this court may do to remedy this if the respondents show that whatever service was provided was within the state's available resources? Just keep that in mind, and also just consider that you might not be able to get to your other points given your time constraints.
Should I answer the question that now should I relate to the issue of
Understand with your team how to deal with that. That is an important consideration together with that of damages that you see.
I will now summarize my submission and then any opportunities for the essence of the submission was that the failure of the officials in respecting and protecting and fulfilling their obligations in terms of the Correctional Services Act. In that line, they infringe on the applicant's constitutional right to health, an environment, to life and dignity. I shall now proceed to any opportunity for order to deal with the second issue.
You may proceed, Councillor.
Justices, in this court, may I continue from the issues that have already been addressed by the co-counsel, Mr. Rango. I had already prepared a structure of how I would address the court, but with the leave of the court, may I attempt to address the question that was put to my co-counsel in relation to the leave campaign. Perhaps my co-counsel also, if there's anything to add, the court is not satisfied. May I attempt the court's view?
Please, Commissioner.
There's a court. This honorable court refers to the brief of facts in front of the court. The facts, okay, my computer is giving me a problem. But if the court considers the facts in paragraph 11, the applicant in this matter had approached the High Court. Having approached the High Court, the case was dismissed. And he then approached the Supreme Court of Appeal. And the Supreme Court of Appeal also dismissed the matter. And the matter was dismissed on merits. So, our reason for appeal, or the reason why this Honorable Court should grant us leave to appeal, is on that very reason Justice Baitoli provided, saying there's cases that are already present, or current cases that deal with such issues. But in our opinion, or in our submission, both the High Court and the Supreme Court failed to comply with the existing precedent. Hence, we approach this court saying there is some prospect of success in dealing with this matter, and the court should agree with the applicant on the merit of the matter. That would be my submission. Thank you, Justice. Now it seeks to deal with the second issue. The second issue,
So just to make sure I understand your leave to appeal submission. You say that where the High Court departs from precedent set by the Constitutional Court, that gives rise to what? A constitutional issue, or an issue related to the Constitution, or an arguable point of law? What is the legal ground for jurisdiction? That's what I'm trying to get the applicant to articulate.
the ground for a leave to appeal to be granted is on that fact that it is in the interest of justice that the court makes a decision on this matter, because that's why, because the applicant had approached the High Court, and the High Court.
I understand, and I don't want you to spend a lot of time on this. I'm trying to get your side of the debate to explain just the jurisdiction. Where do we get the jurisdiction of the court arises in distinct circumstances, where there is a constitutional matter, where there is an argument of general public importance, where there is an issue related to a decision on a constitutional matter. So where in those are you saying you fall? I understand that you're saying the problem is that the High Court and the SCA did not apply the legal standards set by this court. But where does that fall?
I think I get your question, Justice Baitoli. Our case then falls on the fact that there is a constitutional matter, because there are constitutional rights that are being violated by the state. So it then gives to the constitutional. Thank you, Justice. May I deal then with the time that I have, may I deal with the second issue? Assuming the first issue has already been addressed, and where we failed or we didn't address the court actually referred to our heads, we believe we sufficiently tried and addressed the matters there. In relation to the second issue, the issue here is in fact, in relation to the second issue, the issue here is carved out from paragraph 70 of our heads of argument. And the way we word the issue is this application deals with whether the applicant's constitutional rights have been violated by one, the arrest by South African police services. Two, has these constitutional rights been violated by the Correctional Services Department through its detention subsequent to the arrest. Now, to deal with these issues, I will deal with them in phases. The first phase, which will be, I call it the unlawfulness of the arrest, and which is dealt with in paragraph 71. The second phase is the unlawfulness of the detention. The third phase is the implications for what is it then, what's the effect of these violations in relation to the applicant's constitutional rights. And so, going straight into the first phase, as it were, dealing with the unlawfulness of the arrest.
Can I also just ask you to make sure that you have to come clear in my mind that what exactly the applicants are asking. The case of Lee, on which you place some reliance ultimately depend on the delictual element of causation, and particularly on factual causation, although the justice is also debated legal causation. I couldn't understand from your head whether you have taken issue. The High Court dismissed your claim because you could not establish factual causation. And I couldn't work out from your head whether or not you are running a delictual case on causation, or you are running a constitutional case that is unrelated to the delict that is the causation.
To briefly address that question, Justice Mugwai, my understanding is that that question would relate more specifically in terms of how we drafted our heads to the third issue, and my co-counsel may address that. Yes, I continue dealing with the issue. The unlawfulness of the arrest, which I submit that, which I put to paragraph 71 of our heads. But really, what we want to look at, what the court wants to look at there from paragraph 71 is, because our submission as the applicant is that the applicant committed no crime, committed no criminal offense whatsoever. Hence, that is just an opening statement of saying there was no reason to arrest. The arrest was lawful. But further than that, we submit that the court may have noticed when reading our heads that we try and look at possible scenarios where could this arrest by the South African police be justified. But in the interest of time, I will
Don't change the test. Don't change the test. The question is, was there a reasonable suspicion that a crime was committed?
Justice Sowell.
That is CPA. That's the question we need to take us through, given the facts.
Well, Justice Sowell, our submission is that the test may be that, but the arrest, as far as we also read, in terms of our submission, the arrest, and as far as we also read the heads of the respondents in the matter, they also focus on the fact that the arrest was effected in terms of section 41B of the criminal procedure. But in section 41B, the court in Darwin versus Minister of Law and Order addresses that or interprets that. And it points out 4 jurisdictional factors that must be met for that provision to be informed. And so our submission is that some of those, in fact, our submission is 2 of those are not met. Perhaps the court may disagree with us on the issue of suspicion, but the court must agree with us on the 4th or the jurisdictional factor that relates to, and these jurisdictional factors are listed in our heads in paragraph 78. And one of them is that, in fact, I may point out, one is the peace officer, the person must be a peace officer. Secondly, they must entertain a suspicion. Thirdly, the offense must be in Schedule 1 of the
Can I give you a lifeline? Can I give you a lifeline in relation to the question that came from Justice Sewell? That what you say in your argument is that the suspicion that was used to justify the arrest was that he was smoking and being in possession of a cigarette. But your claim is that that's not an offense. The offense is selling a cigarette. So they should have formed a reasonable suspicion that he was selling. So the mere fact that they caught him smoking could not reasonably mean that they caught him selling.
Precisely, Justice Mugwai, that is our submission. That is our submission from paragraph 76. That is our submission. But we we take that submission fair, and that submission is very correct, Justice Suwela. But I intend to also address the other issue or the other jurisdictional factor. The fact that provision, sections 41B, requires that the offense that this officer is suspecting must be an offense in Schedule 1 of the CPA. Now, the other submission is that the offense that was suspected of selling tobacco or tobacco products and so forth, that offense is not an offense listed in Schedule 1 of the CPA. But Schedule 1 of the CPA also provides perhaps a more inclusive provision saying even offenses that may not be listed, but offenses that deal with that would result in a punishment more than 6 months and without an option of the fine. But a proper reading of the regulations, level 3 regulations, which this officer suspects have been violated. In terms of those regulations, in fact, Regulation 11 or Amendment 48 of those, the punishment for violating regulations is that you are punished with, you may be punished in prison for for not more than 6 months, or may not exceed 6 months, which is directly contrary to what's required in terms of the CPA or Schedule 1. And secondly, it requires that there may be no alternative to the fine. But here, the violation that is also alleged or suspected, in fact, in terms of the regulations, there is a provision that you may be fined or you may be fined and imprisoned. So clearly, the case should fall right on the ground, together with the grounds that Justice I told you there assisted me with. Both of those grounds, the case of whether we submit that the arrest was unlawful, there would be a submission in relation to that point.
Counsel, I'm going to rush you, but be mindful of time because you still have your co-counsel to raise some questions.
As a co-counsel, then we can deal with the second issue in the interest of time, which is the phase or second phase unlawful detention. Our submission is that we would like the courts to remember that the applicant does not bear the burden of proving that the detention was lawful or not. And this is a position in terms of Minister of Justice versus Hoffman. All that the applicant must do, and I'm on paragraph 85 of our case. And the point the applicant makes here is simply that it suffices for the applicant to make a submission that the detention by the correctional services was unlawful and unjustifiable. Simply on the ground, that should be enough. And the duty does not allow the applicant to prove that it was unlawful. But that is not all.
The respondent saying that the minute there was a detention and then bail was denied, it was out of their hands. And I also wanted to think about in the papers when we say respondents, which of the respondents we actually referring to in relation to which issue, but it's something that you will then actually draft more because certain things are attached to the first respondent, certain things are attached to the second respondents. Just be mindful of that in the future. But I just want you to get a quick answer to their submission that there was a detention, then there was an application for bail, and the bail was denied. So in relation to this extended detention or the detention during which then contracted COVID, who of the respondents are you saying is liable because they say there is authority that it was the court that then denied bail?
Justice, thank you for the question. Our submission would be that in relation to that issue, we deal with these detentions or point of detention. There's a point where the applicant was detained before he was detained in the police station as well. And the reason of detention there was The applicant in the matter was charged with
Because the number of what the question was, in other words, which of the respondents assumes what liability?
So just
If you could start by answering the question from the presiding judge, which respondents assumes what liability? That's the question.
The second, the correctional services, the correctional services, the first responder, sorry about the first responder.
And is responsible for what?
Is we submitted their detention. The first respondent detaining the applicant was unlawful. And we submit that because the reason for just the detention itself by the Department of Correctional Services is sourced from and misplaced reason of arresting. So our submission is that the applicant should not be there. The applicant should not have been arrested. And that arrest which flowed to him being charged for violating regulations and which led to him being detained by the department. Essentially, therefore, I can't say this. Both the respondents should be held responsible in the circumstances because they played their role.
Council, I gave you a mindful of time, but I think when you say both, I want to understand what you're saying, the first and the second, because the correctional services receives prisoners with court orders, and they can't turn them away because they will be violating obligations. Just something to think about, even if you don't respond to it now, but it's something that practically when you're seeking relief against a respondent, you must be clear about what are the obligations, when do they start, when do they end. Because that links with the liability of what you hold them accountable for. So I will allow, I think my sister has a question and then you can.
As a follow-up question, is it your submission, if I understand it correctly, that staffs acted unlawfully in using their discretion to arrest the applicant rather than simply summoning him or warning him to appear on the charge of suspicion of dealing in tobacco, and that he ought not to have been arrested for the purposes of securing his appearance at court on that charge? And secondly, if the applicant's concern is that bail ought to have been granted by the magistrate, would it not have been appropriate for the applicant to have sought to have taken the bail decision on review or appeal?
Well, the decision for the bail, Justice, was that the applicant, the reason for the bail was denied was that the applicant the magistrate gave the applicant a flight sheet. And it denied, he gave the applicant a flight sheet. And so, in those circumstances, with the applicant not having those papers as of yet, so it may have been less prospect of success in terms of how then, in terms of appealing that decision, now knowing that there may be a possibility of that as well, of him being undocumented.
Could you also just answer the first question? Then the first question, if you remember, is it your submission that police should use that discretion to silence rather than detain him on the suspicion of dealing in tobacco?
Thank you, Justice. Our submission is that the police should not have done anything because the applicant was not doing anything wrong in the circumstances. The applicant was simply having a smoke outside of his house with him in our reading of the facts within his place of residence as required by the regulations. So the police shouldn't have done anything because the applicant was not violating any law. That would be our submission. May I proceed? Perhaps in the interest
Chief
of...
Counsel, maybe you get into wrapping up your submissions because you still have co-counsel. I'm using my discretion today, I'm the Chief Justice of this country. To be fair, I think we'll have to add some time to the respondents when we make submissions. I hope the organizers will find that, but we've taken quite a bit more time with the applicant, so do not stress, we will also get the extra time. I'm trying to keep time, and I'll check with my colleagues that I've kept time. So you may proceed.
Thank you, Justice. Well, in the interest of time, I may also deal with the third point or the third part of our submission, which is the implication of the arrest and the detention. That, in summary, what we submit is that the consequence of both the arrest and the detention is a violation of the applicant's constitutional rights, which is very close to the main issue as well as the second issue. That if the arrest and the detention had not occurred, the applicant's right to freedom and security would not have been violated. The applicant's right to freedom of movement would not have been violated. And so our submission is that if the court agrees with us that the arrest was unlawful, and if the court agrees with us that the detention was also unlawful, the implication of those lawful decisions or conduct, that lawful conduct, was a violation of the applicant's constitutional rights.
I think what worries me is, if I may ask, we've dealt with the unlawful arrests arising from breach of regulations, COVID-related regulations, but you've not addressed us on the breach of immigration regulations and the Act, because that also includes a further component and reason for the arrest and detention. And it's a very material component for illegal immigrants in this country.
I have just to see if I'm getting correctly, Justice.
No, I can say you haven't addressed us on the further detention on the grounds of him being an illegal immigrant in the country. And you've got a whole lot of facts that could have helped the applicant.
But we addressed that without wasting much time on the court's time. We attempted to address that question from paragraph 94. That also that's charged, but we addressed it in relation to the bail. But fundamentally, what we submit is that in terms of the Refugees Act, so a person who is a refugee was seeking asylum, and they apply for asylum. At the point where they make the application, or the application is pending, they will not be prosecuted or charged for violating the Immigration Act and so forth. So our position is that, but in this case, the center or the common way the applicant could have applied for asylum was closed due to lockdown and so forth. So he could not have made the application. And so even that charge, our submission would be, it wouldn't be justifiable in the interest of justice, because he could not do anything. It was out of his control. He could not have applied with offices control. That would be our submission.
Are those your submissions on your points?
Yes, those will be our submissions to the court. Those will be all our submissions.
So, is your co-counsel?
And my co-counsel will address that issue.
That issue.
Honorable Justices of the Constitutional Court, I'm here to address the third issue of termination, which is whether there was a sustained systemic failure of the Department of Correctional Services to put reasonable as well as adequate measures to prevent the application from contracting COVID-19 virus. I would like to distinguish this from the first issue by stating that the first issue dealt with the class of rights, whereas this particular issue deals with the issue of contraction of COVID-19. Whether the measures put in place were adequate enough to combat probably the spread or contraction of COVID-19 by the applicant. So for us to be able to, first of all, depart,
on this issue. We also need to look at some of the suggested means that have been put forward to curb the spread of COVID-19. And some of these have already been noted by the First Council, so I'm not going to draw much on them. But in summary, things like screening, wearing of nose and mouth covering masks, social distancing of 2 meters and regular disinfection, as well as the hand washing with the use of sanitizers or rather soap, are some of the measures that have been put in place. Now, it is common, of course, that if you look at the conduct of the Department of Correctional Services, some of these things are not done. For example, the screening I was mentioned before, which is, comparatively speaking, in the case of me, was due to superficial. And now I'd like to address the question that was posed earlier on about what could have been done better. But instead of using a self-reporting system, there could have been an increased level of proactiveness from the Department of Correctional Services. For instance, by the checking of temperatures on regular intervals, as opposed to just waiting for someone to say that they're feeling a particular set of symptoms. Because that's placing too much of an obligation on the prisoners themselves, who are themselves are vulnerable people, who are in need of protection. So to assume that they're going to step forward and able to be proactive in that regard could have been oversight on their part. Furthermore, things like lack of ventilation and free-flowing air are things that can be tied to the spread of the virus. And this was also mentioned in B, where tuberculosis, which moves in a similar manner but not the same, was deemed to be, one of the issues or one of the catalysts to the spreading of that disease. And it's something that is sustained in this case. If you look at the lack of masks, for instance, and we'd like to also address some of the possible arguments that may be brought forward, especially pertaining to.
Could I ask you, now that you're still at the beginning of your argument, maybe you can help me to understand what's happening here. So liability in dealing will not attach to the land unless you can establish that your client contracting the virus was factually caused by the department. Now they can factually cause it either by doing something, which is sometimes called commission, or by omitting to do something that they are legally allowed to do, which is sometimes called an omission. Where do we stand here on this fact? What is your case exactly?
Our case is that, thank you so much, Justice, for that question, for clarification. Well, the applicant submits that it's due to their omission. The omission of putting in place adequate measures to combat the spread of COVID-19 led to that spread.
So this is not a case of commission, it is a case of omission.
Precisely.
Now, you've got to establish the legal obligation to do something. What is the legal obligation?
Now, according to the case of, for example, I'll push you before where we'll deal with the issue of obligation when we tackle the remedy of constitutional damages. But for the sake of addressing the particular question we have at the moment, I will refer the court to a case that is determined, which was a commission of the Minister of Safety and Security in Anna, where the state has a constitutional duty to respect, promote, and protect all constitutional rights. Now, we then endeavor to show which particular rights are implicated, and they were addressed by the First Council. We essentially highlighted the rights that were implicated and the rights that the Department of Correctional Services was meant to number one, respect, promote, and protect. So, in that regard, some of the obligations are, for example, providing a habitable situation for prisoners to live in, which is in line with human dignity. And some of these issues, as I said, have been already canvassed by the First Council. So I don't want to belabor this point, but I want to know if the justice will be satisfied by the issues.
No, you may proceed. I'm still not sure if I understand in our point that is the substance of the complaint. Because you have not said there is a rule flowing from legislation or flowing from international best practice, which is a tangible thing I can apply in order to assess the omission, because you've now nailed your colors to the mask of omission.
Okay, so thank you so much, Justice, for clarifying that question. I think I missed it the first time around, and I really did it to the courts for that mistake. There's one oversight on my part. But what I'm essentially trying to state here is that there's a positive obligation on the state act, right? And this is encapsulated in legislation, particularly the Correctional Services Act, which is the provision of inter-area habitable conditions suitable for habitation, preserving human You know, some of these obligations also flow from the regulations of the correctional services, the correctional services regulations, which also demand things like screening beforehand for communicable diseases. And some of these obligations, as I proved earlier on, were flouted, or rather some of the steps that we were supposed to take were flouted, which led then to the violation of the applicant's constitutional rights. So some of these obligations are encapsulated, number one, obviously through section 35 of the Constitution, which is the rights of prisoners, but then also in the Correctional Services Act, which has also been touched on by the First Council. Now, when we move to the issue of causation, the case of Lee basically gives us a test, or a verifying test, when it comes to omission, in terms of cases where there's say that police or where there's a positive obligation on the department, for example, we say against drugs. And it essentially told us that the question is whether the conditions under which the applicant was detained was more likely a probable cause of contracting the disease than what would have been in the case that the required measures would have been put in place. And I would like to further clarify by stating that one does not need to also submit that putting in place those measures would have completely eradicated the possible, for example, contraction of COVID-19 virus. One simply needs to substitute the impugn conduct with lawful and reasonable conduct, which is what we are basically, tackled when we shared some of the ways of dealing with the COVID-19 virus and killing its spread, which are also canvassed in the Green State of Facts. And for the sake of time, I will not repeat them as they have already been orchestrated throughout the oration. But now, due to the time constraints, I now move to the limit that we see, which is the constitutional damages. And I want to refer to one of the questions that was brought before by Justice Nani, where, if I wrote it correctly, you were interrogating the appropriateness of the relief, considering that one could also seek a structural entity, or possibly seek a structural entity. And my learned colleague rightfully canvassed that and said that we are also weary of traversing. Oh, sorry.
I think I all spoke at the same time as Justice Wayne, so go.
No, you can go ahead.
I'm still trying to make sure that we don't make this topic of federal position, if that is the end of the argument. So, can you just confirm, is it your case that under the Constitution, the respondents had an obligation to provide for conditions of detention that are consistent with human dignity under Section 35? Section 35 generally touches on, in short, the obligation that specifically speaks to human dignity. No, I understand, but I just wanted to confirm, if I'm right, that your case is they have an obligation as the Correctional Services Department to provide all prisoners, including the client, with conditions of detention that are consistent with human dignity. Justice, we do not submit that that's the only section that informs that particular. I understand, but do you also say it is one of the sections? It is. Do you also say that the respondents were aware that there is an appreciable risk of COVID infection in the conditions of the detention? That is also one other submission that we make. And you say that it's precisely because of the crowded conditions that risk became appreciable.
among other factors, such as the ones that have already been outlined.
And you say, given the duty and the risk of which they were aware, they then fail to take reasonable steps to meet that duty.
Precisely.
Thank you.
Now, I'll address your point now, Justice Simon, and I apologize.
No, go ahead. I was just checking Justice to know what the follow-up.
No, I was just appreciating the further lifeline to.
Thanks so much.
I'm sorry to I've made provision for extra time, but I think you have 3 minutes to. So,
All right. Since I have 3 minutes, I think it's befitting to then tackle the remedy that we seek. And in this case, it's in particular constitutional damages. And we'd like to refer the court to the cases Justice Stein, I intend to address your question as well in this way. Yes, according to Forces the Minister of Safety and Security, relief for constitutional damages enforces the availability of any other remedy. In other words,
Let's tell me what the difference is between judicial and constitutional damages. Okay, the sense of your appreciation.
Okay. The difference is that, the remedy from the intellectual perspective comes from satisfying the 5 elements of the intellectual claim. And not necessarily relying on the obligation of the state in terms of the Constitution to discharge a positive duty, or rather to uphold, respect, and promote the rights of every individual.
In constitutional damages?
Pardon?
And constitutional damages?
Oh yes, I said in my oration, the intellectual claim on one hand focuses on proving the 5 elements of delict, and pursuant to proving those 5 elements of delict, one comes for the court to request the remedy, which is in the form of intellectual claim. Yes, in constitutional damages, the remedy flows not from satisfying all those elements, but the particular focus is on the rights that have been violated. In other words, it relies on a positive obligation to uphold the rights in the Constitution. That is entailed by the state agency. Alright, so now, as I said before, it's becoming sure, the state has constitutional duty to respect, promote, and protect all constitutional rights. And in this case, we are not asking for an internet, for instance, because we are essentially evaluating the conduct that has happened. This is an ex post facto inquiry. And we are not essentially focusing on, for example, a broader perspective of what the state is supposed to do as instructed by the court.
So let me put it this way. If this court does find there was a violation, systemic violation of detainees' right of access to health, or that there was an obligation on the state to have prevented the spread of COVID infections. If mindful of the response of your learned colleague on the separation of powers, if this court were to find this systemic violation, what would the benefit be for a just and equitable remedy for one person receiving a financial payout, which could be construed punitively and will also have a bearing on the fiscus, as opposed to this court directing the respondents to report back to this court on what steps it will be taken to put adequate measures in place so that this does not continue the systemic violation to affect more detainees.
Thank you very much for that. Thank you very much for that question, and it's going to provide basically the segue to my final or concluding approach. Now we say that constitutional damages are appropriate because, as you all said, anyone who alleges a violation of the constitutional right can approach the court for appropriate relief. And appropriate relief, the court is guided by, number one, the need to be just and equitable. Number two, the effectiveness of the remedy sought, and number three, the suitability. Now we allege that on the just and equitable side, we say that the general society is going to be prompted to assert their rights more. And on the issue of effectiveness, we're saying that by granting that particular remedy, the state will start, in other words, trying to be proactive in order to avoid the pile-up of possible constitutional claims that may arise from their failure to to address some of these issues. In other words, it's going to encourage the state to actually work on these issues instead of.
I apologize to keep interrupting you, but is there any evidence that the mass of unlawful arrest and detention claims against the Minister of Police, which are damages paid out to individuals paid for by the taxpayer, has done anything to curb the incidence of individual staff officers, for example, in making unlawful arrest and detention? Why would an individual constitutional claim be of assistance in ensuring that this conduct is stopped?
Well, as mentioned earlier on by the first council, this issue goes far beyond the interest of one individual. It affects the rights of all prisoners. Now, if all prisoners are aware of those rights, the state is more inclined to ensure that the conditions provided are more suitable in order to avoid future claims regarding these particular matters rematerializing on these services.
Okay, you can remember, but my sister's question was actually that, well, you're assuming that that is the case, that they will shape up because they don't want to be sued. And we've already in our system, there's so many cases of the state being sued for money, and it has not changed things. So how is that going to change the system? Because your starting point is that there's a systemic failure.
Well, thank you for that clarification. Well, I would revert to that to my previous argument by stating that when an issue goes beyond the interest of one individual, and especially in this particular circumstances, we are saying that I wanted to touch on, for example, the meaning of appropriate relief in three phases. Number one, that of course the just and equitable issue which I already addressed, the effectiveness of the remedy, and thirdly, the suitability of that remedy. And we said that in the current facts, it should also be borne in mind that these current facts require this particular remedy. And despite the effectiveness or lack thereof of the remedy, a right still exists. I don't know if I managed to answer the issue. That there's one
I think that's a very difficult and important question. And when you look at the relief in 144 that you seek, it just doesn't tire. And I'm sure you get the cue from my sister Slayman's question about the appropriateness of the relief, because that's the most important part in your case. What was this court order? For example, we are asking for compensation for loss suffered when we have nothing to provide to this court to take off what those damages are. So waiting the relief, and especially in constitutional litigation, is one of the most important things if you are going to be trying to litigate for broader change.
Thank you very much for the remark, Justice. But right now, seeing that, I don't know if you'd like me to address that claim.
No, it was a comment to just help you.
Thank you so much, Justice, for that comment. Yes, the court is really indebted to.
I'm sure your time is up.
Yes, I now move to the prayers just to finish off. I really apologize as questions kept coming. Thank you so much, Justice. The applicant seeks an order in the following terms, and therefore humbly prays that one, the application for leave to appeal be granted, that the judgment in the High Court be set aside, and that the first and second respondent be ordered to compensate for the loss suffered by the applicant. And that's also the first and second respondent cater for cost of suit, including the cost of counsel.
Thank you, Counsel.
That's the court.
Thank you. Respondents, are you ready? Okay, and as I mentioned earlier, we will accommodate if questions come to about time. We'll just make sure that it doesn't go over the time that they had. Just one quick point, why do both sides not like numbering the aids? It's an error on our part. But in future, remember, because it's easier to refer people to your aids if the court to refer and actually from the issue. if you do an index, you then also include page numbers. It's just not doing that. You must remember. Okay, you may proceed.
If it pleases the court, my name is Moot George. To my left is my co-counsel, Mr. Taro Washune, and to my further left is my other co-counsel, Ms. Samantha Smith. And we appear on behalf of the respondent in this matter before this honorable court. If it pleases the court.
Yes, the respondents, who's going first? Okay, proceed. Thank you. You will have your 3 minutes, protect your time, and then use the receiving questions. Thank you, Mr. Machulera.
If it pleases the court, I, Mr. Taro Washune, together with Ms. Samantha Smith and Mr. Moot George, are counsel for the respondent. Justices, I shall be meeting for a minimum of 8 minutes. Ms. Smith and Ms. George shall also be meeting for a minimum of 8 minutes each. Justices, Section 172 of the Constitution of the Republic of South Africa regulates the powers of the courts in constitutional matters. In such sense, that the courts are entrusted with the utmost responsibility to invalidate matters inconsistent with the South African constitutionality. These provisions also allude that such rulings should only declare invalidity and inconsistency to the extensive effect of such matters. Such rulings should also be found to be just and fair. Justices, it is of paramount importance to realize that the court doesn't need to prove, the court doesn't need the state to prove that the extraordinary preventative measures implemented during lockdown were perfect. In fact, the wisdom of the executive is not justiciable, only the legality thereof. Justices, please find it in you to judge the case according to reasonableness, legality, and not based on the syllogism of wisdom. As it may please the court, justices, please refer to page 2 of the respondent's stated letter arguments. As counsel for the respondent, I will be discussing the first argument in that there was no systematic failure by the Department of Correctional Services to implement precautionary measures to avert infringement upon the applicant's constitutional rights. My co-counsel, Ms. George, will be speaking on the second argument being that the Department of Correctional Services acted reasonably in raising the applicant's unlawful conduct in the realm of regulations in question, and that this case before the court doesn't equate to a letter of constitutional damages. Justices, my co-counsel, Ms. Samantha Smith, shall then address the court on how there was no systematic failure by the Department of Correctional Services, and that the matter before the court equates to judicial damages as opposed to constitutional damages. When this court considers its jurisdiction in this matter, it's important to bear that the High Court did not rule in favor of the applicant's case. The Supreme Court of Appeal did not even hear the appeal of the applicants, as they failed to meet the common law requirement that the case must be deemed to be successful in a court at prima facie before such case is heard. As it may please the court, may justices please refer to paragraph 4 of the subset of their arguments. Justices, it goes without saying that last year our lives changed rapidly in the name of preserving the human race. Justices, a pandemic struck the world, and subsequently, governments from around the world had to implement national and international
jurisdiction or not.
Please provide me with context, Justice.
So that I don't hear.
Please provide for me context.
I don't understand. But my question is, do you deny that it's court has jurisdiction or not?
No, Justice, but I was merely submitting to the court rather than very important to already consider how the previous courts or the under courts have already ruled on this matter.
So there's no dispute that we have jurisdiction?
Yes, Justice.
All right, thank you.
Justices, it is also important to note that such national lockdown policy was found to be constitutional and therefore valid as the court judged in the case concerning the legality of the National Coronavirus Command Council and its powers and recommendations to be justiciable. The case reads as the Geertz and others humans were public.
May I ask, is there any challenge before this court on the legality or constitutionality of the regulations that were put in place? And if not, why do we need to understand the global context of the need for the regulations?
Justices, there is a fair amount of importance to understand that the applicant's case is claiming that there is a sense of illegitimacy or a sense of unconstitutionality in the regulations by the state. So, Justices, the mere...
If I understand the applicant's case, there's illegality in the manner in which the regulations were implemented in the context of measures in prisons and in the context of discretion to arrest. My question is, has there been any challenge to the constitutionality of the regulations? There is no case by the applicants for the regulations in their entirety to be set aside on this matter.
Justices, it is also paramount importance to understand that the respondent's case is not entirely based on what the applicants have submitted this morning.
No, I mean, the question is, why should we be treated to a global understanding of the necessity of the regulations if they are impure?
Justices, it's of paramount importance to understand this pandemic really struck the whole world. Therefore, it's also important for the courts to interpret the international standard of which the South African government also used to formulate the regulations. Justices, please refer to paragraph 5 of the substantive arguments. According to the petition clause of the Constitution of the Republic of South Africa, rights in the Bill of Rights may be limited only in terms of general application, and given that the limitation is reasonable and justifiable in an open and democratic society based on dignity, equality, and freedom. Justices, thus counsel for the state submits that it is important for this honorable court to keep the letter essence in mind that during such a time that, as they are disputing this case, the state had the power to limit what is not done for non-local rights in their actions. Justices, it is important to appreciate the fact that our transformative document places paramount responsibility on the state to act in the best interest of the vulnerable. For such a case, the Honorable case set the expected standard to be followed by the court when judging measures implemented by government entities to prevent the violations, also considering the allocations.
So that comes to the central case we are dealing with here. My understanding of your argument on this first point is that you took adequate, so-called adequate precautionary measures because you released some prisoners and therefore reduced the prison population.
Yes, Justice.
And I cannot see anything else that you did.
Justice, please allow me to continue with my argument. I shall get to that.
All right, well, if you go to paragraph 14 of your head of argument, can you show me anywhere else that shows other steps other than reducing the prison population?
Justice, from paragraph 13, however, the respondents and arguments as the Department of Correctional Services implemented processes such as the screening of inmates to prevent the spread of COVID-19, as they could not reasonably afford to test each inmate upon admission. Secondly, the Department of Correctional Services also took measures to reduce the risk of transmission by decreasing the inmate population. This was achieved in the Department of Correctional Services, implemented the release of prisoners from correctional services facilities in order to reduce the overcrowding of prisons. So, Justice, those are measures implemented by the correctional services authorities.
That's exactly the point I was getting to. Is there anywhere else that we can get some evidence of what you did in addition to the reduction of the prison population by releasing people? That's the only thing that we find that you did.
The synopsis of facts do really provide the precautionary measures that were exercised by the government. Also, Justices, it is also important to understand that sanitizing played a huge role in this course of combating the pandemic. And we also need to understand that we only acted upon reasonable measures for her in our available means.
Isn't it rather inconsistent though that on the one hand you would release prisoners and then on the other you would accept prisoners for what could be classified as rather petty offenses?
Justice, please put my co-counsel to get to the question as this more of our argument. Justices, it's important now. Justices, reasonable testing is satisfied as follows. Firstly, the state acted in accordance with South African constitutional provisions or with the legislation which sets the rules.
I really apologize to the presiding judge, Mr. Matuli. We have read your heads. We are expecting oral arguments, not a reading on the heads.
Justices, the respondents have listed the annual report of the Judicial Inspectorate of Correctional Services. One can know that from 2010 to 2011, 2010 and 2011 to 2018 to 2019, there was an improvement in the protection of the rights of the correctional services facilities.
Council, can I ask you a question? I'm still going back to Council Judge Leonard Brother's question about measures that were taken. The applicants come and say you didn't do enough to make sure that the prisoners were safe. Like even if you say in paragraph 40, Department of Correctional Services increased the numbers, did they decrease any numbers in the particular place where he was being held? Did they have masks for the prisoners? Did they have sanitizers? How often did they make sure that they are screened in terms of the temperature, not even going to testing them? Just from a practical perspective, you come into court to say, we did all we could reasonably do to reduce. We know what the regulations say, we know how different places of work, places of schooling, actually put certain measures in place. And I think, his question was, apart from saying we decrease the numbers, also thinking about what the applicants are saying to the court. Did you do anything? If you had the 29 people in one cell, then it's supposed to be, I think, 16. How are you ensuring that those people are, social distancing obviously is gone out of the window, but if they have masks, where the masks change regularly, if they have sanitizers in their cells, we don't know whether there's anything in relation to that that minimizing off the risk. And I think that's what my brother was getting to.
Justice, the Department of Correctional Services acted in accordance with their regular means. At that time, masks were even properly nationwide in supply, or internationally even so. Sanitizers was made one of the forwards and preventative measure to try and curb the spread of COVID-19. About the overcrowding of prisons, it also paramount importance to understand the Department of Correctional Services does appreciate the fact that the prisons were overcrowded. And as a matter of fact, we also have an obligation to actually keep citizens away from these prisons. Therefore, it is highly unreasonable to even suggest that the Department of Correctional Services should possibly release more prisoners than the country deserves to be protected in the sense of protecting those whose rights are reasonably limited.
Thank you. You can proceed with your argument.
Justices, please allow me to explore how the Department of Correctional Services has made a reasonable test. Firstly, the state acted in accordance with South African constitutional provisions or rather legislation sets the record straight that the state must act in accordance with the legislation when manifesting the protection of people's fundamental rights. Secondly, the test of reasonableness in such a case is to determine whether the state use their means to achieve a progressive realization of such rights. Moving on. Thirdly, to support the respondents' active reasoning in the realm of protecting constitutional rights in question, Justice, one must keep.
Sorry, Mr. Matuli. So you do make this point about the provisions in the Constitution about progressive realization of the rights. But in this particular context, I want us to reflect, you can reflect with us a bit about what are you attaching the progressive realization of which right of this particular prisoner in this context. Obviously, you always talk about it in other rights, the right to education is all those rights. But in this particular instance where the applicants are saying he has this right, firstly, he should not have been detained. I know your co-counsel is going to deal with that. Secondly, when he was detained, he should have been kept in certain in his facility of certain standards or guidelines are there for what must be provided. So now my question is, within those things that are required, read together with the COVID-19 provisions that we have, how are you applying that duty to progressively realize the harm? What does it mean? What are you saying to us?
Justice, the applicant's detainee was not even detained for not longer than 1 month and half a month. So it is incredibly unforeseeable that they expect a great amount of special treatment for him, because prisons should work with human dignity, reiterated equality. It's also part of the Correctional Services Act that they really do respect the ground of the Republic of South Africa. In fact, what needs to be understood is that during such a time, most of us do not have the luxuries which they are advocating for. Council, our learned colleagues came here and tried to question the freedom movement, which was recently restricted during our restrictions. So it makes us wonder if they have a proper interpretation of the law, because they can come and claim that the applicant's right to freedom movement was unreasonably limited by the Department of Correctional Services. Justices, one must keep in mind that the Constitution in mind the state is expected to manifest guaranteed rights within the available resources. In supremacy, the court stated that the limited resources are a serious factor standing in the way of the state not being able to protect constitutional rights. The applicant's claim to have been violated, justices, it's important for our learned colleagues to fathom that in paragraph 41 and paragraph 113 of their substantive arguments, the applicants are in sync with our submission as the very essence of leading Minister of Correctional Services, that the state is not required to obligation to make sure that persons will not contract the virus in question. However, it is the state's paramount obligation to place reasonable preventative measures in place within the available resources. Thus, counsel for the respondents admits that the state did have reasonably in case as they implemented reasonable measures within the available resources. Justices, also in paragraph 11 of the council's substantive pair of arguments, the respondents admit that they were in sync with the constitutional court case of Minister of Health v. Truth and Action, campaign that the state has to and did implement what was reasonably possible within the limited resources to protect and uphold the obligations relating to inmates' rights. In Mazibuko v. City of Johannesburg, the court held that if the court takes no steps to reasonably protect the rights and uphold their obligations, the court will require the government to take steps, and if the government adopts unreasonable measures, the court will review these measures to determine if it meets constitutional standards of reasonableness. A measure implemented by the government is only unreasonable if there is no provision made to protect such rights. Justices, counsel for the respondents arguments that this is of great importance to appreciate the efforts invested by the Department of Correctional Services in light of protecting fundamental rights, fundamental and socio-economic rights, when judging the reasonableness and legality of the respondent's case. If there are no further questions, if it pleases the court, I now hand over to my co-counsel, Ms. Minnie George.
Thank you, Mr. Moot.
If it pleases the court, as previously mentioned, my name is Minnie George, and I will appear on behalf of the respondents in this matter before this honorable court. The applicant in this matter is alleging infringement. Yes, yes. Oh, sorry. The applicant in this matter is alleging infringement of his constitutional rights in the context of COVID-19, and therefore this sets great precedence for future cases to come, and it makes this case a case of great public interest. In light of the applicant's allegations, I will be speaking on behalf of the respondents on the matter that the South African Police Service's decision to arrest the applicant and the decision by the Department of the Correctional Services to detain the applicant were not violations of his constitutional rights, and therefore he is not merited the awarding of constitutional damages. If it pleases the court, may I direct the court to paragraph 16 of our heads of argument. I will first address the topic of the lawful arrest of the applicant. According to Section 40, subsection 1 of the Criminal Procedure Act, a peace officer may, without warrant, arrest any person who commits any offense or attempts to commit any offense in his presence. Therefore, the respondent submits that the decision by the policeman to arrest the applicant was lawful on the grounds that he had reasonable grounds to suspect the applicant of committing an offense. Now, the text for the reasonable suspicion of committing an offense can be found in our heads of arguments in paragraph 17. The case of Minister of Safety and Security, Mr. Sokoto, applied the reasonable person's test, but a reasonable person's test for the highest standard. In that, the police officer, in the police officer's position, could have concluded that there was indeed reasonable and probable grounds for the arrest. The respondents in this case would like to respectfully highlight two facts to the court today. The first is that at the time of the applicant's arrest, the selling of tobacco products, such as cigarettes, were strictly prohibited under alleged regulations level 3. Secondly, at the time of the applicant's arrest, this country had been under strict lockdown between the hours of 9 p.m. and 4 a.m. On that account, the respondents would therefore like to submit that there was indeed reasonable and probable grounds for the arrest, on account of the fact that the applicant had been arrested and caught smoking in a time when the sales of tobacco products had been restricted for a period of about 5 months. We submit that it was reasonable.
This is not really the problem of your case, because you're moving from smoking to purchasing. So, what exactly is the reasonable basis that you bought the cigarettes?
Thank you for your question, Justice. I was about to get to explaining the legal instruments. The arrest on the fact that the applicant was caught smoking in a period of time when the selling of tobacco products had been restricted for a period of 5 months. Therefore, we submit that it was reasonable and it was probable for the respondents in this matter to have assumed that the applicant was either selling tobacco products or buying contraband products.
On what text was that assumption based?
We are placing it as one of the probable. Thank you, Justice, for your question. We are stating that because the study had been prohibited for about 5 months, the respondents could have concluded and determined in his mind that it would be very hard to get cigarettes legally, and therefore he was either selling the cigarettes and smoking because he had the means, or he had bought it in a timely and from an illegal manner.
On what facts?
I believe that I didn't answer your question. Please can you rephrase it if you need
the assumptions that it could have, and it could have, and it could have, was based on what?
And like previously mentioned, the fact that what he had seen on face value and what he has determined is that it hadn't been illegal for 5 months, and this person was somehow in possession of a cigarette.
All right, so I mean, let's explore that. How reasonable is it to make that assumption in this instance? Did he question the accused? For example, to establish his facts so that he can then formulate this assumption so that the court can test how reasonable it was to do so in that time?
Thank you, Justice, for your question. The respondents are submitting that this assumption, we are submitting it on the probability, which is one of the factors to be taken into case, reasonability and its probability. On the question of whether he did question the applicants in this matter, this was not clarified in the set of facts, and we answering that question will imply to making up set of facts in this case. However, we do submit that we are submitting this on the probability, meaning that in all the options that could have been available to the respondent in that time, one of the options was that he probably acquired these cigarettes through illegal means, and therefore we submit that this makes the arrest lawful, in accordance with other things that I will address now.
Ms. George, the applicants are saying that he could have gotten a warrant arrest. This was not a case where he immediately needed to arrest them, or he could have been given a warning to appear, if I recall correctly in the submissions. So what is your response to that? So they're saying that the type of crime they committed is such a one that, in terms of our law, it may not have been necessary to actually then arrest and detain him.
Thank you, Justice, for the question. If you follow our heads of arguments in paragraph 19, you will see that section 205 of section 3 of the Constitution does place a duty on the respondent, which is the police officer, to protect and secure the people of the Republic and to enforce the law. We therefore submit that arresting the applicant was the respondent acting in his duty by enforcing the law. And if the applicant is submitting that he should not have done that, they are therefore submitting that he should not have acted in line with the Constitution and with his duty. Does that subsequently answer your question, ma'am?
It's fine for now. I think my sister has a question.
As a follow-up, do you accept that should a substance official believe that a crime is being committed, they have discretion whether or not to arrest to secure an appearance in court? So I'm not questioning that in their mind they saw sufficient grounds to charge. But do you accept that there's a discretion thereafter whether or not to arrest for purpose of detention to secure their appearance in court? And if so, how was that discretion applied in this case?
Especially taking into account that this was an arrest without a warrant.
Thank you, Justice. We do actually submit that there is a discretion on the policeman to decide whether to arrest or not. And we did submit that he used his rightful discretion in deciding to arrest. We also submit that when the applicant was arrested, he was given two options according to the set of facts, one of which was to pay a fine rather than to sit in a detention period.
They didn't give him a lawyer. Goes there, they say, you want to pay a fine, but there's no lawyer, they don't intend it that you have the right to a lawyer.
Thank you, Justice. I'm not understanding what the question is.
Well, you know, in paragraph 7 of the hypothetical case.
I can't really think.
In paragraph 7 of the hypothetical case, this is what it says. For liable to not have legal representation during this time. That's why it's being interrogated in the police station.
So therefore you're asking me about his legal presentation?
Well, about the cogency of the submission that he had the option of paying a fine in circumstances where he doesn't even have a lawyer.
Thank you, Justice. The facts do not allude to the fact of whether he was offered a lawyer or not. We are just aware of the fact that he did not have a legal presentation. Furthermore, on the matter of the curfew, the applicants in paragraph 73 of their heads of arguments have submitted that the applicant was at or within the place of residence at 2:10, which was 45 minutes past the long curfew period. And because we are not sure whether he was actually in the building or because of issues of boundaries in undeveloped settlements, the respondents dispute that on the basis of the fact that the set of facts that we have been given are not negotiable. And if the set of facts say that he was near the place of residence, it definitely implies that he was not at his place of residence. Therefore, he was caught outside of his place of residence, outside of the curfew time, meaning that he was caught committing an offense and therefore breaking the law. And on that evidence, we do submit that the police had a measure of discretion. He had found the applicant smoking a cigarette. He had found the applicant outside of his place of residence, outside of the curfew time, and he had therefore used that rightful discretion to come to a conclusion to arrest him. And we submit that therefore his arrest was not unlawful. Moving on to the detention of the applicant in this matter. In the case of the Clerk versus Minister of Police, it is stated that an arresting police officer cannot be held liable for an unlawful detention after a court hearing where the presiding officer in that case failed to fulfill the responsibilities regarding the detention of the arrested person. This same principle is applied in the case of Minister of Safety and Security versus Tokwana, where in that case the respondent's unlawful detention ceases to be unlawful on the basis of the facts that he did stand.
Can I just make sure that I get clarity on the question you debated, Justice Sweden, which is, what is the reasonable basis on which cops acted and they arrested him? Your point is, If you did not have, that's now on the reasonableness. Say one.
Arrest.
Yes, the reasonableness of the suspicion.
Okay, please.
So the rest is in the law for unlawful. It's not just against reasonableness, but it's the mindset of the police that must be tested against reasonableness. So your point is, if you take into account that for 5 months there were no cigarette sales, you get a person who is smoking. They don't grow the cigarette, they get it from someone. And therefore, it's reasonable for a policeman, and it's not reasonable, probably fair, just a suspicion. That's what the section says. Say that suspicion is reasonable because you must have bought it from someone, and you must have bought it. And for that reason, we should not find that it was unreasonable as a suspicion, which is a very low standard. So that's the ultimate point of it.
I am submitting as the respondent that exact thing, and also the fact that it could have been one of the probable scenarios of how the applicant got access of the cigarette. And as the case does say, reasonable and probable ground, we are submitting on that basis that the arrest was lawful.
Yes, but what I'm trying to say is, what we must look at is a reasonable suspicion. And at the level of suspicion, which is a very low threshold, it would be okay for a policeman to say, 5 months, no cigarettes have been sold, we catch you smoking, therefore you must have bought it.
Therefore, you may have bought it.
Yeah, well, you probably bought it.
You probably bought it,
And
yes.
therefore we make a test in section 41B.
Section 41B speaks about cases that are infringed under Schedule 1.
Yeah.
That is not what the authority that we, the respondents, are relying on. We are relying on the test in Section 41, Section 8, subsection. Section 1, paragraph 8,
Yeah.
which states that he may arrest if he suspects committing or attempting to commit an offense.
But that suspicion is still a reasonable suspicion.
We submit that it is reasonable suspicion of justice. I was addressing the court on the detention of the applicant and how this is lawful in accordance with what the respondents are submitting. We have stated that in Minister of Safety and Security, Mrs. Obama, the same principle that I have previously mentioned was applied in that the respondent's unlawful detention ceased to be unlawful based on the fact that his bail application was dismissed because, if I'm correct, the court did decide that he was at flight risk. Therefore, when applying these principles to this matter before the court, we as the respondents have made that the respondent's detention cannot be considered unlawful, and furthermore, the alleged unlawful detention cannot be the responsibility of the respondents because the applicant did stand before the High Court in the bail application where the presiding officers of that case had decided to further extend his period of detention and dismiss his bail application. Moving forward to my last point, the point of constitutionality.
That should sue the magistrate.
I am not taking liability of anyone, I am just stating that in this matter before the court, we cannot assume liability. Thank you, Justice. Finally, we the respondents submit that the detention of the applicant and the arrest should not be considered a violation of his constitutional rights, but rather a limitation in accordance with Section 36 of the Constitution. His rights were limited in order to uphold the law at that time because they would not have been better methods to curb the spread of COVID-19. And therefore, they were not a violation of his rights, only a limitation, and therefore he does not merit award for constitutional damages. Justices, Honorable Court, if there are no further questions, and if it does please the court, I would like to hand over to my co-counsel, Samantha Smith.
Very tough. Did you have a question? Okay, Justice Samantha says she's fine. Thank you, Ms. Judge. Ms. Smith.
Justices, my name is Samantha Smith and I will be appearing on the court about the third issue before us today. This case can be summarized into one word: reasonableness. This case is not about emotions, but about the realities faced in correctional centers due to the dynamic landscape of COVID-19 and how the correctional service authorities acted as best it could with the available resources. This virus has not been present for an extended period of time, and thus the correctional service authorities acted as best it could with the available resources. I will be addressing the court on three main issues. Firstly, that there was not a systematic failure due to the conditions in the legal correctional center, but the conditions were due to the lack of resources available to these centers. Secondly, that the legal causation element, as said in the common law, was not met, and thus damages cannot be claimed. Finally, if this court does decide to award damages, the legal damages would be the appropriate relief rather than constitutional damages. If I may refer justices to paragraph 26 of our heads of parliament. The conditions in the legal correctional centre were due to the resources available to correctional centres. In Lee versus Minister of Correctional Centres, it was held in paragraph 8 that the court dealt with legal causation and how things like overcrowding can lead to the transmission of contagious diseases such as TB, or in the case before the court, COVID-19. The court in that case awarded the legal damages, but did not decide to introduce an incident for the correctional services to improve the conditions, as this court is aware of the financial strains that we face in correctional centres. In versus Minister of Safety and Security, at paragraph 72, it was also held that there is a very high demand on state resources due to all the social and economic commitments that we have, and thus the state struggles to uphold all these commitments, but we try our best under the limited resources. And also, as COVID-19 was such an unforeseen pandemic, there was not many resources available. Therefore, the respondents firstly submit that there was not a systematic failure in the conditions of the legal correctional centre, and this was due to the limited resources. As
what is the submission on causation? You've heard our opponents. What they say is that their case is an omission case.
Yes,
the board obligation directly under Section 5 of the Constitution to maintain conditions of detention that are consistent with humanity. You were aware that there is overcrowding. You were also aware that the overcrowding creates conditions for the spread of COVID, and the measure that you took in those circumstances did not meet the obligation you had under the Constitution. I'm trying to break your heads since Webber to find what the facts are on which you rely for claiming that you took all the reasonable steps. And I ultimately came to paragraph 14, which I put that to your friend, to your colleague. Is there anything on the facts that you did? Because even in the section you are addressing, I can't find anything.
So Justice, just to clarify, are you asking what the reasonable and the adequate measures is that being instituted?
Yes.
Thank you, Justice. Justice, so firstly, what the prison authorities did, when inmates came into the prison, they screened all inmates in accordance with the established protocols to assess the temperature and asking a series of questions. If these questions were answered yes to any of these questions, you were referred to a medical practitioner for further examination. Secondly, hand sanitizer was provided throughout the prison in order to keep everything sanitary as COVID-19 can be reduced to hand sanitizer 70% alcohol. Then, during the time of the applicant incarceration, the prison was under lockdown, thus visitors could not come into the prison, thus bringing the virus into the prison. So it then goes to the assumption that if COVID was not in the prison, it would not be able to come in as well, as the wardens would given masks and would screen on a daily basis. Finally,
sorry, Counsel, you said only the wardens were given masks. What about the prisoners? Because masks have been said to be that's what we're all trying to wear them at all times. The first defense to try and limit spreading and contracting. What about the prisoners? Any provision for masks for them?
Yes, Justice. The prisoners that were responsible for providing the food were provided masks, but as there was a global shortage of masks, inmates were not provided with masks, as it would not have been reasonable in the situation to direct very important PPE to correctional centers rather than to healthcare workers, as there was a global shortage that we were facing. Thus, we did the best we could with the available resources such as availability to master tests and also available resources at the time. Thank you, Justice. If I may refer the court to paragraph 30, we respondents deal with the legal causation element.
But what happened in this particular detention facility? What I can't work out is what steps were taken here when Mr. Moyo was taken.
Yes, if I may refer you to the set of facts of paragraph 30, it specifically deals with the requirements and reasonable measures that I just mentioned. The wardens were screened on a daily basis. The wardens were also provided with masked incoming units, were screened of a series of questions and such forth. I don't think that answers the question, Justice.
Yes, I understand. But the presiding judge has already touched you on the question of masks. But also there's another problem, which is we rely on self-reporting.
Yes, so we rely on self-reporting as it is unreasonable to ask the wardens or the limited staff available to correctional centres to in some, so the total prison population is 155,000 people, so it would be unreasonable to each day screen every one of them. So we screen them when they come into the prison, and if they have any complaints or they feel any symptoms, they can report it to the wardens and then they will receive medical attention.
Yes, and then only those who answered affirmative ultimately get attention.
You just at start, but if later on, during when you are incarcerated, you feel ill and you report it to the warden, then you will receive medical attention. As it is to the court.
On that point, I don't know whether you finish to address it later. I do have a concern that I noted that Mr. Moyo presented with the symptoms, but I think it's only 6 days later where he was eventually sent to the hospital. And I'll go and read down my list. Somewhere I noted it here in my notes. But he was not given immediate medical attention. There were a few days that passed before he was moved, and that's a concern, because if you say, if they self-report maybe they're already on day 7 of the day 7 or 8 of the COVID-19 infection, then your response must then be an immediate one, the one that really deals with the situation to minimize further problems or the escalation of the symptoms and such things. So what do you have to say about that?
It's just, so the set of facts are not really extensive to why he was not given medical attention, but from what we did know from the set of facts is that there was a shortage of medical staff available to correctional centers, and thus it took some time for them to attend to. But as soon as they assessed the situation and realized the gravity thereof, he was immediately taken to the hospital in order to receive adequate treatment.
Yes, and what we know about COVID that was not your client of COVID is that firstly, masks will help. Secondly, congestion and overcrowding assist in the spread. Thirdly, you need ventilation. And the facts here, we know that there is no ventilation. And the facts, we know there is overcrowding. And the facts, we also know that there are no masks. That's why I come back, what are these reasonable measures?
Firstly, problems like the free flow of air or the lack of sonar ventilation was due to the design and construction of the building. So that was unfortunately outside the control of the respondents at the time. And then secondly, as I've mentioned, but if you want me to further elaborate on any point, we did screening, we did hand sanitizer, we released emails in order to try and reduce overcrowding as we were aware of the issue. We instituted a lockdown throughout the prison in order to try and contain infections from spreading.
Yes. And you also claimed that you actually did something because you reduced the prison population. But the reality is that, although that was announced by the president, it was in fact not implemented. We had 90,000 prisoners, but at the time, only 7,000 prisoners had been released. So even this proclaimed step of reducing the population, in fact, was not in fact implemented.
Yes, so whenever the same process was being followed, it did take some time, but we were busy with this in trying to be as safe for the general population, as we only released inmates that committed lower crimes, and thus we wanted to take caution in deciding who was released in order to protect the general population as well. If I may address the court to paragraph 36 of the written argument. If this honorable court does decide to award damages, it should be judicial damages instead of constitutional damages. Constitutional damages in general are avoided to be awarded as it restricts the government's resources. In South Africa, generally when there's infringement of right, judicial damages are awarded. In First Justice Minister of Safety and Security at paragraph 84, it was also held that giving constitutional damages does not solve the problem, as it does not stop these infringements from happening. As can be seen in Kumaba versus Blake, Minister.
Thank you, Ms. Smith. On the issue of constitutional versus electoral damages, I have a question to put to you, which I also put to the applicants. While the applicants have not sought any structural relief against the state, what is your response to the question of this court's inherent discretion to, of its own accord and in giving the just and equitable remedy, to compel the states to report back to this court on what measures it will put in place to ensure there is a sustaining spread? Given that we're likely to have COVID in a year or two until we can achieve herd immunity, and that there may be continued spread asymptomatically in business. What are your submissions on this court of its own accord, compelling the states to report to this court on adequate measures to put in place?
Yes, Justice. The response would comply with that is the request of this honorable court. As our main objective is to protect the inmates as best we can with the available resources, as it is also the government's long-term goal to vaccinate the inmate population and achieve herd immunity as you have stated. So the respondent would comply with that if that is your submission, because that would be more reasonable than allowing for constitutional damages, as that will further restrict our very limited resources as stated already, and we need those resources to further these precautionary measures and procure things like vaccinations in order to improving our protection of the inmates. So we will gladly comply with that, Justice.
Well, the applicants say that to bridge separation of powers, the respondents say that they didn't comply.
Yes, Justice, the government is always happy to comply with any question of this honorable court. So that is the request of the judiciary, we will happily comply. If we look at the case of Minister of Police versus Mboweni, it was also held that the breach of statutory duty constitutes appropriate relief as electoral damages to compensate for the injured party. And if we allow for constitutional damages, we will now be replacing the league with a constitutional infringement where there was already a common law remedy that was sufficient in this case. The respondent therefore submits that in the case for the court, the electoral damages is a greater claim than constitutional damages, as it is in the interest of society. Thus, Justice, because the legal possession element in this case is not made, it does not warrant damages, as it is not in the interest of society. The respondent's three main submissions are as follows. Firstly, that the correctional service authorities implemented reasonable and adequate measures in order to prevent violations of the inmate's rights. Secondly, the arrest and detention of the inmate was lawful and the right was therefore limited justifiably. Finally, there was no systematic failure in the local correctional center's conditions, as the conditions were the reality faced by the limited resources available to us. The respondent prays to this honorable court to dismiss this application and any further or alternative relief deemed appropriate by this court. In the matter before the court, the applicant's case does not merit the awarding of constitutional damages. And if there are no further questions, and it is the court, the respondent has submitted the case and thus rests.
I was just curious to know that you ask for costs. What about the judgment of this court in violation?
Yes, Justice, we are familiar with that case. As said, we do have limited resources and thus it is this court's discretion to decide if allowing costs or not. But obviously the state has in a time like this very limited resources and thus we did ask for costs. But it is at this court's discretion to decide on that or not. As it pleases the court.
Any questions from the bench? Thank you so much, Mr.
Thank you, Justices.
The applicant will have 5 minutes. Is it 5 or 10 minutes? 5, it's 5 minutes.
Justices, I intend to rebut some of the, or respond to some of the arguments submitted, or submissions made by the respondent. May I start with what may be the easier one? The easier one is the respondents in their head of argument. They did not point out exactly what section of the section of the CPA they rely on in terms of their arrest. He simply pointed out that the arrest is in terms of section 41. And now
this was clarified in oral argument when I was in George, so I don't see where this is going.
If the justice will allow me, then in response to that question, when the question was put to my colleague, she then replied and said they rely on section 41A. And section 41A says a warrant, a police officer may arrest any person if the person commits or when there's a commission of the crime. The crime has been committed. The crime has been committed, or there is an attempt to commit the crime. That is the requirement of section 41A. It does not.
The smoking was in the presence of the police officer, so the police officer saw the commission of the crime. That's the point as well.
Well, Justice, the argument by the respondent is that, in fact, the facts are clear on saying that the police officer arrested on suspicion or on reason.
Yes.
And second,
okay, sorry.
And
I appreciate your trying to bring about the case, and I mustn't interrupt you. Make your point.
Then the response to that, if the court looks at the facts say the arrest was affected on the reason or the suspicion that there was a crime being committed. It's not saying there was in fact a crime being committed. The basis for the arrest is that there is a reason or they suspect the commission of the crime.
Yeah, but the policeman cannot decide if the crime is being committed or not. He just formulates a suspicion. It's the court that decides if the crime was committed or not.
Well, Justice, the provision itself provides for peace officers, it talks to peace officers, and it says, peace officers, if they see a crime being committed, where a crime is being committed, they may arrest. And so if that's the wording of the legislation, then it sort of foresees a peace officer who would see a crime and decide that this is a crime, this is clearly an act against the law, or this is clearly violating the law. But even that, if that is not enough, then the suspicion, the crime that would have said to be committed would not, there's no evidence that the crime is being committed, the crime of selling. There is only suspicion that the crime of selling, which is prohibited. So even then, even if they would say the crime is being committed on the scene, no one was selling, he was smoking. So what crime? And the crime is selling. So if he was not selling, there is absolutely no crime being committed. So that would be our submission that our submission would be on the facts, not on some manufactured fact, on the facts respectfully. On the facts, the arrest was effected on suspicion. And arrest effected on suspicion are catered for in terms of section D. But because that will not satisfy the respondent's case in our submission, then they read to section A, which provides for incidences where the police officer sees it clear. It is clear and undeniable that this person is hitting this person or assaulting this person. There's a clear evidence that the crime is being committed. There's no suspicion in that case. So our submission is that section 41A caters for such situations, not situations where there is a suspicion or reason that a crime may be committed. But in fact, the crime is not even being committed. That would be our submission.
I think one of the concerns is that, I'm just moving on to something that's troubling me, is on the continued detention of the applicant. You have not joined the magistrate, you have not joined the National Director of Prosecution, and none of these parties, but the argument was made that none of these parties were responsible for the decision to deny bail and to continue to detain. What do you say to that?
Well, our submission to our submission, Justice, would be the question itself from the issues and from the brief of facts. It provides context. It would be the applicant would consider under normal circumstances outside the context of what is happening. Perhaps there may be no ground to hold the correctional services accountable or for the continued detention. But in the context of the facts, where the facts are clear in pointing out the prisons were already overpopulated, and secondly, not just that, there was also an order by the president to release prisoners. But what did the correctional services do? They insisted on keeping the applicant for over 2 months. And so that continued detention would, in fact, in the circumstances of there's an order that prisoners may be released, and secondly, the fact that prisons are in fact overpopulated. And so in that context, keeping the applicant, continuously detaining him, when that will constitute a violation, it should be held accountable in that respect. And in that specific respect of the context. That would be our submission.
Is that all?
Yes, that would be all, Justice, but just one.
What do you say about the fact that the respondents have said that they leave it in our hands, but you did not say anything about why the court should not be granted against your client? Maybe in conclusion, can you just quickly speak to that?
That is very true. Mr. Tabara, so to still get us into the seconds.
30 seconds. 30 seconds.
30
seconds.
Sorry.
Please, Justice, if you may indulge me by please question.
No, it's just a quick one about the fact that they see costs against your client in the papers, although Ms. Smith has said that they're leaving it in our hands. But we just want to hear from your side, if your client brought this matter before us, if we find against them, what would be your argument against the court order against your client?
Against our client regarding
costs.
Oh, okay. Now, we would like to submit that the court order against our client in this particular case would not be appropriate for two major reasons. The first reason is, number one, we have to look at the position of the client, considering the harm that they've suffered as a result of the conduct, or rather, the inadequacies.
Where is this one? There is a authority of the Constitutional Court in bylaws, which says if you bring the constitutional case genuinely, legitimately, in good faith, and you lose against the state, you should pay costs. So why are we now concerned with anything other than the bylaws principle?
Thank you very much for making that submission, Justice. In that case, since the issue has already been resolved by the committee, then I shall not be able to continue there.
It's fine, but it's a very important point to remember in the future, because the case, if you're trying to straighten a court order, which is massive in the Constitutional Court, you should know the authority that actually covers the client against court order. But that's fine. Thank you so much.
Much obliged.
Court will adjourn for 30 minutes. Is that correct, please?
You guys.